Hello, and welcome to the Tianshan Centennial Library. My name is Lance, and I'm a librarian here at Southwestern Adventist University. This video is part of a series where I talk about the library, how it works, and what skills you need to do research well. In this video, I will briefly talk about intellectual property rights and some related concepts that will be useful to know about during your time at Southwestern. In some ways, this is a complicated issue, with some lawyers dedicating their entire careers to handling intellectual property and nothing else. I will do my best to explain these concepts as simply as I can, but keep in mind that I am not a lawyer or copyright expert, and that my goal is to help you understand some basic concepts and not to provide legal advice. Whenever someone creates something, that creator has rights regarding who can use that creation and how money is made from it. If you watch sports or movies, you'll often see warnings about how it's against the law to reproduce or redistribute the program without the consent of the copyright holder. Without getting into what this looks like in the business world, there is one important area of copyright law that concerns educational situations. That is the concept of fair use. Fair use is a legal doctrine that promotes freedom of expression by permitting the unlicensed use of copyright-protected works in certain circumstances. Certain types of uses, such as criticism, comment, news reporting, teaching, scholarship, and research, are examples of activities that likely qualify as fair use. This means that you don't have to get permission from the copyright holder to do things like write a paper about a book that includes quotes from the book. This includes other forms of media as well. Keep in mind that you will still need to create a citation. Another interesting part of copyright law is what's called public domain. Intellectual property rights don't last forever. They eventually run out. In those cases, works are said to have entered the public domain, which means they belong to everyone, and everyone can use them however they like. While the actual physical painting of the Mona Lisa is owned by someone, the image of the Mona Lisa is old enough to be considered public domain. So, if you wanted to use the image of the Mona Lisa to sell cheeseburgers, that would be permissible. Public domain timelines vary by country, and even within just the US, it can be very complex to figure out when something has become public domain. As you can see from the information on screen, there are several different timelines for public domain entry depending on how and when something was made. For example, content created by or for a corporation enters the public domain 95 years after it was first published. Mickey Mouse was created in 1928, so starting in 2024, his original design will be considered part of the public domain. That means people other than Disney will be able to publish Mickey Mouse content legally. There is one more area of intellectual property that is helpful to know about. Some creators don't like copyright law as it currently stands, and will voluntarily publish their works under a different set of usage licenses called either Creative Commons or open source. Works published under these guidelines can be used by anyone freely if certain conditions are met, those conditions usually being that proper attribution is given, or that any work made from them is also considered open source and free to use. The most popular works created under these guidelines are teacher resources and computer software. I personally am a big fan of open source software and use it a lot. Well, that's it for this video, guys. Thanks for listening, and don't forget that we have a bunch of other videos that can help you out. If you have any questions or need more help or information, don't hesitate to reach out to the library at the contact information on the screen.